All right, hi again, Attorney Steve. Hey, we're going to talk about injunctions today, but I'm going to do it through a current case, literally today. So I would call this breaking news with Attorney Steve. All right, this involves this gun case from New Mexico, and apparently there was a shooting of, I think it was 3 kids, and the governor stepped up and said, look, I want to do something about this. This is a serious health issue, and I'm going to ban carrying guns in public. Apparently you're allowed to carry guns in public in New Mexico. And she came down with an order that said no more carrying guns. It's temporary in public, no more carrying guns. So we have the National Association for Gun Rights and Foster Allen Haynes plaintiffs versus Michelle Grisham in her official capacity as the governor. And so, but we're going to talk a little bit, and it looks like there was some additional consolidated parties in here from what I can tell. We the Patriots USA, Gun Owners of America, Gun Owners Foundation. So there was, looks like the court consolidated the cases. So they sought a restraining order saying, hey, wait, this violates the Second Amendment rights. And some people said, well, I saw on a post, somebody said, well, you know, this doesn't apply because it's a state. You know, states, you know, they don't have to follow the Second Amendment. I said there is such a thing as incorporation. Certain amendments are incorporated into the 14th Amendment, which is applicable to the states, okay? Things like your First Amendment, your Second Amendment. Those are fully incorporated. There's others that are partially incorporated. I don't want to go into all that now. But as you can see right here, this was the restraining order. Plaintiffs, individual firearm owners, or Second Amendment advocacy organizations, collectively plaintiffs, have moved for a temporary restraining order, TRO. So traditionally the process is you file for a TRO. That's an immediate stop to the order that she issued. And then usually there's a more full hearing where parties fully brief everything in a restraining and seeking the permanent restraining order. So this is the TRO, usually good for about 10 days. But let's take a look here. So they sought this under Rule 65. Law students out there, when you're going to get a restraining order, this is going to show you how you do it, how you argue. You have to prove a few things, okay? So without going into too much, she issued a public health emergency order saying that you couldn't, here it is right here, on September 7th, 2023, responding to a rise in mass shootings and gun-related deaths. New Mexico Governor Michelle Grisham, the governor, issued executive order. That's one of the powers of both the president and the governor, basically the president of the state, if you will. They can issue executive orders. This is where you don't have the state legislature voting on it. You don't have Congress ruling on it in the federal side. So she issued an executive order declaring a state of public emergency. It's a public health emergency of unknown duration, but that's a little open-ended there. Due to gun violence, the governors directed the New Mexico State Departments of Public Health, Homeland Security, and Emergency Management and Public Safety to collaborate with the governor's officer to provide a coordinated response to implement the executive order. The following day, September 8th, New Mexico Department of Health Secretary Patrick Allen issued a public health order, DDD. Okay, so among other prohibitions, that restricts open or concealed possession of a firearm by any person other than a law enforcement officer or licensed security officer within cities or counties averaging 1,000 or more violent crimes per 100,000 residents per year. DDD. Okay, so we go down here. Let's get to the injunction part. So obviously there were some people upset about this. Here's what you need to prove, okay? To obtain a restraining order, here it is. Plaintiffs, and this is great bar review stuff if you're going to be talking about this. This is very bar testable. The moving party must, the plaintiff must show that the moving party, that's the plaintiffs, will suffer irreparable injury unless the injunction issues. That's number one. 2, the threatened injury to the moving party, that's the plaintiff, outweighs whatever the damage the proposed injunction may cause the opposing party. 3, the injunction, if issued, would not be adverse to the public interest. And 4, this is the big one, there is a substantial likelihood that the moving party will eventually prevail on the merits. That's the key, okay? The likelihood, here we go, the likelihood of success and irreparable factors are the most critical, okay? All right, so here we go. You can pause these if you want. I'm going to let you see all four factors. The court, ultimately, the federal court judge issued the TRO so that her order is now stayed pending further litigation. Plaintiffs have shown a likelihood of success on the merits that their Second and 14th Amendment rights, okay? So the Second Amendment rights get incorporated into the 14th Amendment. This is how it works. Rights to publicly carry a firearm for self-defense will be violated if the PHO remains in effect. Under the Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So that's a limit on what the government can do. That's what the Constitution is. It's basically a limit on the government's power. All right, so the court found that the Second and 14th Amendment looks like they have a likelihood of success. And you can stop and read all this. I'm not going to go into all that. I just want to kind of roll through this and keep the video short. Let's see, the court finds that the analysis in Bruin will likely control in the instant case, given that here the plaintiffs challenge a restriction on the right to carry firearms in public for self-defense. Of course, this court is cognizant of the fact that the instant case may present issues not explicitly raised in Bruin, McDonald, or Heller cases, but given the directives and holdings of this Supreme Court, the court concludes plaintiff have shown a substantial likelihood of success on the merits of their Second Amendment claim. Number two, plaintiffs will suffer irreparable harm if they don't get this injunction. Court finds that plaintiffs have shown they will suffer irreparable harm if temporary injunction is not issued. Plaintiff suffers an irreparable injury when a court is unable to grant an effective monetary remedy, and what we say sometimes is that money damages will not cure the problem, because many times if money will cure the problem, just go let the parties duke it out and we'll see who's right and who pays who. Here, effective monetary remedy after a full trial is not possible because such damages would be inadequate or difficult to ascertain. It's a Planned Parenthood case. When an alleged constitutional right is involved, most courts hold that no further showing of irreparable injury is necessary. So you have a constitutional right. That's a pretty big deal. Court says, okay, I get it. All right, if you want to stop and read that, if you really want to dig in here, this is the ruling fresh off the press today. Okay, let's go down. The temporary restraining order will not be adverse to the public interest. Plaintiffs have shown that the temporary restraining order will not be adverse to the public interest, as the 10th Circuit has stated. It is always in the public interest to prevent the violation of a party's constitutional rights. Moreover, a state does not have an interest in enforcing a law that is likely constitutionally infirm. Okay, means no good. Although the state of New Mexico raises important safety concerns, at this stage it fails to demonstrate that the public safety concerns overcome the public's interest in preventing constitutional violations, okay? So you can, again, pause the video, read the rest here. However, given the Bruin's clarity, the Second and 14th Amendments, there we go again, the Second, 14th Amendments made applicable to the states, protect an individual's right to carry a handgun for self-defense outside the home. The court concludes that issuing a TRO to prevent the violation of a constitutional right would be in the public interest, okay? And finally, what you'll see in a lot of cases is the balance of equities, okay? Let's balance the rule, the purpose of the rule versus the impingement on the rights. The balance of equities weighing in favor of issuing a TRO, as noted, it is always in the public interest to prevent a violation of a party's constitutional rights. Finding that the balance of equities failed them, here we go, conclusion. The court weighed all four factors. That's how a TRO proceeds. Therefore, it is ordered by the court, the defendants, New Mexico Governor, New Mexico Department Secretary Patrick Allen, New Mexico Public Safety Jason Bowie, Chief of New Mexico State Police, other, are enjoined. That means stop from applying, enforcing, or attempting to enforce, either criminally or civilly, Section 1 of the New Mexico Department of Health's Public Health Emergency Order imposing temporary firearm restrictions, drug monitoring, and other public safety measures, PHO, okay? Here's some other things you can pause and read if you like. I just wanted to get it. That's what we're talking about when we're looking at a TRO, and then usually a full hearing will follow. We will see. how that goes. But usually, I will say, usually when a TRO, in my experience, is granted, usually the final preliminary, the permanent injunction will also issue. But we'll see, you never know. All right, so there's a bunch of orders from the judge. If you want, it's effective 255, must have been granted at 255, went into immediate effect. The court has considered the issue and determined that a bond is unnecessary. Sometimes when you're seeking a TRO because you're stopping something from happening, sometimes the judge can order that you post a bond, 1,000, 2,000, 5, 50, 100,000. Judge said no bond is required. It is further ordered that this matter shall be set for hearing on the plaintiff's motion for preliminary injunction. That's what they're going for next, the preliminary injunction, and then if they proceed, it will go to final injunction. It is so ordered. There you have it, the Honorable David Herrera Urias, United States District Court Judge. So that's it, folks. Fresh off the press, this is the new New Mexico controversy that's going on about carrying guns. As some people say, well, it would be great if the criminals would decide to stop carrying guns. Are they going to follow this order? So there you have it. Current news. Attorney Steve, have a great day. This is not legal advice, general legal information only. Bye now.